Page 26. He just told us, so we're good. Thank you, sir. My name is Mike Fowler, Deputy Commissioner, Department of Defense. General Porteous apologizes for not being here. He's attending a governor's customer service summit, a command performance of sorts. So, with me is Ross Freilich, our finance director. Either he or I would be your contacts within the department. Welcome calls or questions from anyone. The changes in the 06 budget are fairly straightforward and simple. You are all aware, I think, that the Air Force program at Warner Robins is in a growth mode. When we shifted from the B-1 program a couple of years ago to the J-Stars, that unit will eventually be about 3 times the size of the old B-1 program. That continues to evolve and grow. The understanding with the Office of Planning and Budget and with the General Assembly has been that in the supplemental budget we adjust the Air Guard match requirements for federal programs. I think you're aware that the state has responsibility for matching in the Air Guard of 25% of the utility requirements of units and 25% of the cost of maintenance personnel. All of the costs are borne by the feds. With the Air Guard being basically 2 bases, the agreement is that we'll make the adjustments in supplemental once we are aware of the federal budget requirements. The federal budget is never ready before October 1st, and many times long after that. And once we get notice of what the growth and the match requirements will be at the air bases, then we come in and make adjustments in supplemental. The Army is a much larger program. We're able to adjust better within the year with the 2 fiscal years being off sync. So the only increase you see there is an increase of 100,000 state dollars, matching another 300,000 federal dollars for increased cost at Warner Robins. I hope that would be a routine change. There's one other point I'd like to make, and I won't take too much of your time, but one of the problems that we are having as an agency right now is working with our federal partners in that the military is going through a transformation in a couple of different ways. One, transformation within the Army itself, which is obviously affecting our military side and the Air Guard. But at the same time, a transformation to a joint forces headquarters. Now that's changing on the run a lot of our cost structure within the agency. In the 07 budget, you're going to see several positions being changed from federal funding to state funding, and some from state funding to federal funding, some being eliminated. And that's basically due to the blending of Army and Air and state command structure. The problem with that, for instance, a very essential element within our agency, the Director of Joint Operations, which is basically civil support, the elements we provide for help within the state and emergencies, is moving from federal funding to state funding, that and his staff. Now, we've had to make internal changes in supplemental. You don't see the request here, that we didn't know about it in time to actually involve and insert the request. We're making changes in-house. To accommodate this, we're having to eliminate our civilian information officer, which is a problem for us, but something we're doing internally. We're not looking for additional dollars for that. We're just telling you that it's requiring a lot of changes on the run. What we're asking is for you to consider in the supplemental, and certainly in the 07, collapsing our program budgets into a single program budget for the department while we go through this transformation. It's very difficult for us to make moves with the federal and state years, budget years being out of sync. The ability for us to know in time to come to fiscal affairs for changes is difficult. Many of the federal changes and the ability to leverage federal dollars occurs in late September with very little notice, and without the ability to move money among programs, it very much limits our ability to claim additional federal dollars or to fund programs that we otherwise would desire to do. I'll answer any questions about that, but you'll see it in the supplemental as a formal request. We would ask you to consider doing that earlier. Yes, sir. Thank you, sir. Thank you for the comment. Thank you very much. Any questions we can answer? Thank you, sir.
Appreciate it. Might mention one thing, and I need to tell you, we scheduled this hearing, the governor is infinite wisdom, scheduled during the legislative session, all the agency heads, customer service for yesterday and today. And he should have known better, I'll just put it that way. So that's where the general is, and that's where some of the other agency heads are today, trying to abide by that order from the governor. So, next, we would like to hear the Court of Appeals, if you don't mind, please. We've got Judge John Evans with us. Most of y'all know John. Southeast Georgia. John is here too. He's here. Bill Martin, clerk, Danny Kelly, budget director. And I also have given to you today, we got a handout on the compensation comparisons, and I'll also have this afternoon if we need to get additional information to give you at the end.
Okay, I'm Jane Kelly, the fiscal director, and actually we're on page 4 of the tracking document. Oh, is it on? Okay. The first item we have as an enhancement, and I actually have some additional information that breaks that down a little bit. As you can remember, last year I came to you and told you about our space crisis. We'd had a long-term deficiency at the Court of Appeals as far as space for over a decade. Last year it was escalated to a crisis because we were being forced out of our space in the health building because of renovation for that building. Further, it has been escalated this year by the fact that we were supposed to retain 2 of our judges in the health building during the renovation process. The conditions became so deteriorated that we had to physically move them off of Capitol Hill. We need the funds, the additional funding for 2006 supplemental according to the Georgia Building Authority in the 2006. This is very important in the fact that we are now have 2 judgeships off of Capitol Hill, and the space rental for that space doubles January 2007. So we must meet their deadlines to avoid that. By the way, that space rental charge is 4 times what we pay at GBA. As you can see, for an enhancement, I'm asking for the actual project's about $2 million. I had basically done a rough estimate last year. Now this is for both health building and judicial building. We are actually taking the 5th floor of the health building. It's 22,000 square feet of space. And we are moving all our administrative offices, the clerk's office, which needed additional space, and the fiscal office, and all those people displaced except for the judges. We are moving those over to the health building. Then we will, as soon as that space is evacuated from the health building, we are building out 3 judgeships on the 3rd floor. So it's kind of a double project in the fact that we've got to have the space to finish the health building to be able to renovate half of the 3rd floor of the judicial building to bring our judges back to the judicial building. This is going to do 2 things. This is going to give additional security to our judges in the health building, but also it will alleviate, while it alleviates our short-term needs, it does not handle and address long-term. It does allow us to help a little bit of the cramping of the judicial building, but basically it's helping us for those people that are displaced. It does not allow us, in other words, growth room for additional judgeships with the growth in the caseload of the court. This is an immediate need, though, and it does answer all of our short-term problems. Is there any question on that $1 million request? Okay. Right. It's very hard. That would help us with the long-term needs. Absolutely.
We got the speaker to come over last year here at the session. Bill Martin's kind enough. He didn't have just about 30 minutes, but he had enough time to at least see some of their problems. And then we got the governor back in November. Does that sound about right, Bill? Yes. To come over and go through the judicial bill and look at the problems that Appropriations has. And they have, we need to take a feel for it. Y'all would be amazed at how some of the working conditions are. And they are two of the judges that agreed to the equity bill. That was the way Crawford managed it at that time because what was it, Robert?
Georgia Educational Facilities Authority.
Moved out, and you had the lease was already in place, but they are on the short swing, I think, to the end of this year.
January 07. Well, we have to be out by the end of December.
But it is causing logistical problems, especially on files. What do y'all do? Transporting files a couple of
We're a couple of times a day, files, and just to maintain the facility, the additional workload, the filing records, the courses, the judges coordinating with each other. That's only a portion. They're not even on the same panels. So that is very inconvenient. It's quite been a challenge for us to be able to do that.
What's your time frame of getting the work completed?
We are supposed to be able to have the health building finished in late summer and actually be able to move into that space by sometime in the fall. And then they are telling us by December that they should be able to have the judicial, the 3 spaces in the judicial. The clerk's office is fairly open space, so it's not quite as major renovation as the health building to be able to move that and move those judges in. We're hoping by January. Right.
If anybody desires to go look at it, if you'll call, I'm sure they'll be glad to take you through it and show you their problems.
The portion that I gave you of information on the thing, that's just the portion on the construction that I've asked for in the 06 budget. The additional amount that I really don't need till 07, moving cost, and the additional loosed equipment costs that go along with that construction cost have been moved to the 07 budget. So this is the portion that GBA is saying that they require. They've actually got it in a line item being 1.126. Part of that is displacement cost. If you will, I have outlined as far as, let's see, excuse me, let me look at 2006. $49,622 is increase in rental costs for our temporary movement of employees during this transition time. So that equates to the 1.126 figure. So I've kind of broken it out for you there. Is there any additional questions on the space?
Anybody got any questions? Go ahead.
Is there a reason why it has to be in Atlanta? The goal is to get all the judges to be accessible and be secure.
It needs to be near the other courts as far as the Supreme Court. There's a lot of cases that move between Supreme Court and back and forth. So, and the location, I don't know as far as, maybe Bill can answer that question, but definitely it needs to be near the Supreme Court.
We toured this facility last year, and all you got to do is go over there and just tour it and walk through it, and you'll see exactly what you're talking about.
I will tell you that the governor also toured it. If we don't have any questions, I'll move on to the next item. Okay. The next item I have, it's actually number 1 on my list, which is additional funding for computer charges to meet projected expenditures. Okay. Okay, it's the $27,998. That is charges from GTA billing of $6,588 that they previously didn't charge state agencies for PeopleSoft, and we're having to absorb that. So I'm requesting for that additional funding. There's also increase in our online legal research. That was on an escalated contract, so those monies, it was like a 5-year contract, and they changed the rates at the end of the term. We actually use Westlaw and Lexis. It's at about 91%. And of that additional amount, you realize out of operating, about 5% of that is fixed cost, rent, and those type of things that you just really don't have any choice of. So therefore, we only end up with about a 4% of being able to put off supplies, repairs, those type of things. That the online legal research cost was $7,745, an increase. And then the computer charges, the Novell license for our computer software actually had gone up. And so that's the total of the $27,998. We also have, I'm not sure what number it is on your thing, personnel services funding to meet projected expenditures. If you recall, in fiscal year 2005, we had a payroll shift that was incorporated. At the end of the year, we reduced our request for that payroll shift by any vacancies that had occurred during the year, turnover, those things. I actually am under my projection of what meeting my needs for this year by that amount. And that's not increasing any positions that are in field. That's just with the current people on board. That's $15,814. And that is all of the requests I have for this 2006. Are there any additional questions? Thank you.
Before we get to AOC and independence, thanks, Linda. I have had a conversation recently with Linda Klein. Linda is a former president of our state bar. That, I think, was and still is the only female president we've ever had of our bar. And met Linda last night at a reception and she has been very supportive of a program that has been in the state dealing with the violence against women fund, and very much wanted to talk to the committees of subpoena through our subcommittee and appropriations. So I said, Linda, if you would come in the morning, I'll ask chair of the committee allow you a few minutes to talk about it. Would you like to go ahead, Linda?
Thank you very much. I realize that what I'm talking about is really 07, and but I'll talk fast. How's that? I am here to talk about the proposal to move the administration of the funding that brings lawyers to help the poorest women and children who are the victims of domestic violence. And the proposal before you, I believe, is to move that money from the Judicial Council to the CJCC. And the only qualification that I bring here today that I'd like to mention to you is that I was the only woman, the first and like the last woman to serve as president of the state bar. And this all came up. I'm not a domestic lawyer. I've never handled a divorce case in 25 years of doing this. But when I was elected secretary of the State Bar, the first woman elected, it made the rounds in the newspapers all over the state. And I started receiving phone calls that literally changed my life. They were from women who said that they had been abused in their marriages, that their children were affected by it, and they could not get lawyers to help them because they were just too poor. And I asked them about legal services, and they said that they had tried, but the waiting list was just too long to get a lawyer to help them. And they were afraid. They had issues about health care. They had issues about school choice. They had issues about keeping their jobs. And it was very scary. So I just won an election. I had won an election by having lawyers all over the state help me get elected. So I knew lawyers, and I called them. And they said to me, Linda, I'll take 5 pro bono cases so long as one of them is not domestic violence. And they told me stories that again changed my life. They said, I took a domestic violence case pro bono, and the guy brought a gun to my kid's school, where the guy followed my secretary home and threatened her, or called my house. And they said they couldn't help. So I talked to Georgia Legal Services and Atlanta Legal Aid, and I learned that 85% of the cases that come before those two very important organizations have domestic violence as some component of it. And I realized that the lawyers there work very efficiently and effectively on this issue. And I said, well, let's just put some numbers together. If we had funding, what could we do? And we learned that for $50 a case, not $50 an hour. Now, what lawyer can you ever get for $50 a case? But for about $50 a case with adequate funding, Georgia Legal Services and Atlanta Legal Aid principally could help all of these people. So I went to many of the members of the legislature. I went to see people that were representing Governor Miller at the time, and we talked very hard. I got a coalition of 66 community organizations. We did political polling, and we found that 80% of Georgia, urban, rural, old, young, whatever the demographics were, 80% of Georgia thought this was a great use of taxpayer dollars, that we could help save families and we could help break the cycle of violence. And we worked hard together. I worked with members of the legislature. I worked with Tim Burgess at Governor Miller's budget office at the time. There was a lot of discussion about this program. How much money? What would be covered? Who would administer it? And what we decided was $2 million, which was at the time what we asked for. $2 million divided by $50 a case, that will help 4,000 families. Well, what would we do with it? Well, there was some discussion and negotiation. We decided that divorces would not be part of how we would use the money. We decided that we could not use it for temporary protective orders because you didn't need a lawyer for that, and there were lay advocates at the shelters who could help us. No class actions, no immigration. And then we had to decide, well, who would be the protector of this money? Who would be where would the money go? And after discussions with many members of the legislature, with Mr. Burgess on behalf of Governor Miller, the decision was made to send the money to the Judicial Council. Well, why? Because the Judicial Council is made up of all the courts of Georgia except the municipal courts. It's all the judges. And the judges were the ones who told us, and they continue to tell us, where are the greatest needs in our state? Where does the money need to go? They know what types of cases are coming before them and what kinds of lawyers are available and what the poverty population is in their area. The judges are the best qualified to distribute this money. Absolutely nothing has changed since 1998 when we had these discussions, except that we helped thousands and thousands of Georgia families. Well, the first year, the legislature was kind enough to grant us the $2 million. We didn't help 4,000 families. We helped 6,000 families with that money in the first year alone. And this program has just been a phenomenal program. Every county in the state benefits from this program. I hate to use that phrase, it ain't broke, but it ain't broke. I know that there's some discussion about the money and the money going to the AOC. This money does not go to the AOC. The money goes to the Judicial Council. I understand that the AOC has provided some staff support to the Judicial Council, and I understand that there was a concern about there being an administrative fee charged by the AOC. I understand that the CJCC, if they get the money, intends to charge an administrative fee as well. I am here to tell you that as chair of the Lawyers Foundation of Georgia, that is the charitable arm of the State Bar of Georgia, we will assure that the support is given to the Judicial Council at absolutely no charge So 100% of the money will go to the indigent victims of domestic violence through legal services programs and the lawyers who can best help them. I've told you what the money's for. I told you what just an incredible, wonderful difference this money has made in our state, and how 100% of this money can be assured to go to the benefit of all the families. It ain't broke. Let's not fix it.
Linda, is there suspected change in the funding amount, or is this a question of this administration?
Well, there is a request to take the funding back up to $2,178,000. We were at a high of $2,225,000, $2.25 million, and that got cut as state money went away. But I suggest that with the $2,178,000, if that's your pleasure, and no administrative charge, which I can pledge to you will happen, then that's the equivalent of $2.25 million, certainly going to these families that need it so badly. Are there? It's 4% at the AOC is charging. It's about $80-some-odd thousand a year, and that has provided staff support to the Judicial Council at the request of the Judicial Council.
Did I hear you say that the foundation is willing to absorb that?
Well, the foundation is going to provide the service for free, using volunteers or. Right, and of course it's possible that AOC and the Judicial Council may decide to do something else that would be without cost, but what I'm offering is that I can assure this committee that we'll get it done without cost.
Sure. If it goes to, if it's transferred over, now, are you willing to offer that same deal if it leaves AOC?
As I understand it, and I'm confident of this, the money does not go to AOC, it goes to the Judicial Council.
I understand that, but I'm talking about the administration. If the governor moves this to the CJA, whatever, Criminal Justice Coordinating Council, are you willing to also provide the...
I'll have to check with my board. As I understand the way my board feels is that the judges who are the Judicial Council are the ones that are best able to administer the funds. That would be something that I'd be willing to talk about. I know that the CJCC charges an administrative fee for all of their grants. I also know that the CJCC works exclusively with federal grants that come to the state, and it is the Criminal Justice Coordinating Council. This is a civil justice matter.
You're aware of where this came from?
I understood that it came from the governor's office. And I'd be happy to talk to the governor about it, too.
I'm not really that familiar with how this actually hits the street. If you don't represent folks in TPOs, then what sort of services do you provide to these folks?
TPOs, there's a statute that allows TPOs to be done by lay advocates, and there is training that Georgia Legal Services provides for lay advocates. But in the negotiation about this money, several of the members of the legislature felt that if we didn't need lawyers for TPOs, then let's save the lawyers for what they can do best. Access to health care is a very big issue. Housing issues, after there's domestic violence, there are eviction issues. Issues involving school choice. When you're the victim of domestic violence, I learned that you have the right to either stay in your school or go to a different school, even though you're living at an undisclosed location, which is a shelter. Job support. Sometimes women who are victims of domestic violence have attendance problems while they're dealing with their health care and other issues. And these are the types of issues that lawyers who are schooled in poverty law can do very quickly and efficiently. Any other questions? Thank you very much, and I'm glad to come back if I can help. Thank you.
Mr. Chairman, members of the committee, I'll be very brief. Do want to introduce, if you don't already know, Deputy Director Sarah Haskin. She's the, if you request it, she's the go-to person as it relates to any of our budgetary matters and legislative matters for our organization. If I could just give you one brief update as to where we are now at the end of our first full year of operation as a statewide public defender system. We've opened 43 public defender offices across the state. There are 6 opt-out counties, 6 counties that providing alternative delivery services. But we have 43 offices up and running across the state. And I think that the next statistic or figure I'll give you is just absolutely amazing. In 1 year's operation, we have opened over 160,000 cases involving indigent services being provided by the lawyers who are supported by the Indigent Defense Services through our organization. I don't want to be too Pollyanna about it, but we're up and running, and things are going much better than I think anyone expected this time last year. Services are being provided. We still have a few bumps in the road, but we're stepping over those as we go, and things are going well. We were initially requesting $162,206 in the supplemental budget to fund the assistant public defenders that were needed to support the 5 new Superior Court judges that were provided for from last year. However, due to a lag time in getting the opt-out counties funded, and quite frankly, due to some extremely hard work by Sarah Haskin, we've been able to absorb those additional costs that we expected to have to incur in the 06 budget. And because of the combination of the lag time in using the funds that we didn't have to spend initially, and again, I can't emphasize too much, Sarah's ability to shift funds around to absorb the additional costs through other budget programs within our agency, we are withdrawing our request for the supplemental funds of $162,206. That change is already reflected on your tracking budget sheet, and I hope I get the page right. It's page 12 of the sheet, and it shows the House Subcommittee, the state funds, at $42,079,060. So that change is already reflected on your budget tracking sheet. With that announcement, I guess I should say, I don't have anything else to present with regard to the 06 budget. We'll deal with the 07 budget at the appropriate time. But I am ready and hopefully will be able to answer any questions you might have about our operation.
Ask you one thing, how are the cases in the juvenile court? I didn't introduce a bill to add them to the juvenile court. It's been kind of wait and see how the case count, how things roll out. Where are we on that?
We're still really struggling to provide the juvenile court services. We're using attorneys that would normally be providing services in the superior courts to handle those juvenile court cases. The legislation which you passed requires each of our 43 offices to have a juvenile court division, and each office does have a juvenile court division. In some instances, the counties have stepped up and provided, through intergovernmental agreements with us, have provided some additional attorneys that we've been able to designate for the juvenile courts. That's basically shifting the cost and responsibility back to the county to help us provide services. But it's a struggle, but we're doing it. Hopefully, at the appropriate time, we'll have the additional juvenile court positions that your bill provides. But until that happens, Sarah just handed me, right now, we've opened 21,252 juvenile cases. So it's significant. Out of that 161,000, you can see the numbers of juvenile cases that we're handling. But right now, we're handling those with existing personnel and personnel that we're contracting with through the counties. I hope that answered your question.
That's something I think we're going to need to look at as this evolves. But what you've done on that is basically the funding position become the added to juvenile court, and that's one of the biggest areas that I understand is falling back on the counties. Mm-hmm. We had hoped to give the county some relief on what they've been paying. They're continuing to have to pay that now because of things like the caseload that I think a lot of people didn't anticipate in juvenile court. So that's something I think at some point we're going to need to look at in the funding part of it, in funding the position into the service.
Mr. Chairman, I'm sorry, may I follow up with my response. Just very briefly, it's absolutely critical when the appropriate time comes and we can get funding for this. Juvenile defendants deserve specialized attorneys. It is an area of the law. Those of you who are lawyers on the committee know that juvenile cases require special expertise, special training. It's very difficult for those like myself who spend all their time in Superior Court to step down and do work in the juvenile courts. It is a specialty within criminal defense itself, and at some point we hope that the funds will be available for us to hire the specialized attorneys to staff those juvenile divisions in each office.
I want to go into something like and I talked to Sarah, she's going to get right into. We've got on the books the indigent client is to pay a $50 fee. The number of cases you're talking about, I'm thinking in my head, $50, if it were in fact collected, would be a substantial amount to help fund the program, to well take care of what you're talking about is the juvenile side of it. And I saw some figures from Sarah that show like for Fulton County reflected $1,000. From Howard, Georgia reflected $12,000. I think, why are we having this inability? And I know we should be putting on the judge to do it. Do we have something that your office is setting up or can set up that would be a mechanism to help better do the accountability of these individuals as they come through and have the payment of $50? If not, let's get it off the books.
Yeah. Yes, sir.
Mike, you want to answer that or can answer that?
I think, again, there's legislation that will allow, there's two or three approaches that we're taking. One, we're trying to do a better job with the circuit public defender offices of training and making sure that they're doing the things they should be doing to collect that $50 fee. It's a sea change in attitude, quite frankly, that we're having to deal with, and Fulton County is a good example. I just finished issuing a 48-page report about the operation of the Fulton County office, and one of the criticisms that I raised about the operation of that office was the failure to collect the $50 application fee. So we're approaching that internally with additional training, and quite frankly, we're slapping some wrists and saying you're not doing your job and you need to do it. However, one of the things that the legislation, and Representative Crawford probably can talk to this better than I can, but the legislation will give the authority to the judges to put that application fee on the tail end as part of the sentence of a particular probation sentences. We've taken a position all along that if a judge can waive it, which they can under the current legislation, then they certainly could tack it on as part of a probation cost. And some judges took us up on that. A lot of the judges felt, and this is sort of anecdotally back to us, but a lot of the judges felt that, well, if there's nothing in the legislation that allows me to do that, I don't want to tack it on without some authority. And I think Representative Crawford's, Chairman Crawford's legislation and others will address that. And I think that'll be a big help. I think that when I come back before you next year, I'll be able to stand here and give you a much better report on how much we're collecting, and it will make a difference.
Great idea. And meeting as often as we do, even though it's inconvenient, has meant, I think, a lot to indigent defenders, also to some guys. Now, having said that, let me tell you a couple of the problems to the committee about the $50. We've got some of the public defenders in the audience today. That two things public defenders don't like, they're not bonded. There's no other place in state government in the judicial branch where somebody's paid what would be county or state money to representing them. So that's been somewhat of a problem. Now, Lee is sitting out there qualifying who is eligible for indigent defense, and that the county pays someone of your staff the county is paying someone to qualify those individuals. You take my circuit does not, and most of your circuits, do not qualify, do not have a process for anybody to look at that application. I walk in and I say I'm indigent, they represent me. So what we've got some legislation we've been working with indigent defense on that will change that to the chief judge in each circuit would set up a mechanism in each county to qualify the individuals. Now, to qualify them is only to review and to make that determination if they're indigent or not according to the standards that indigent defense, that have adopted. Now, as of now, their rules and regs or their standards say that you can be up to 200% of the poverty level and qualify. That was not put in the statute. That was left up to the council and the rules and regs. This legislation would cap that at 150%. Now, that has come back as a recommendation from most of the public defenders in the state. Felt like that was too high, 200%. And it would cap it at no more than 150%. Now, indigent defense public defender's counsel doesn't necessarily like that. Indigent defense counsel, they don't like us putting it in the statute, but what that does, it would move with the poverty level, and it would give the legislature, because of this budgeting process, a little bit more oversight on those budgets. And it would, I believe that you will see that it will cut down on the number of cases that they're handling. And I'm not here trying to put them out of business. The only thing I'm trying to do is make sure that who needs representation gets it, who can afford it, pays for it. Now, interestingly, in Chatham County, they have the county pays someone there to
Yes.
qualify them also. Isn't that right?
That's correct.
And the interesting thing is, in Chatham County, if you go apply for indigency status, you must sign a waiver for a credit check. And from what they've told me, that's real interesting when you run a credit check on people. You find assets, you find ways to, you find what they call some people are able to hire an attorney. And let me tell you who else is complaining out in the state is the criminal law. Now, Mike and Sarah have been able to, on conflicts, to keep a lot of those folks working, but I have heard from a lot of the criminal attorneys that are saying, and I even had a Superior Court judge call me back in November and said, look, they just represented a guy in court. I did his divorce 2 months before and had his affidavit. I know what he made. So I've got his W-2 form. So we went back. So I had my clerk go back and look at it and pull that and said, they made $135,000 last year in indigent defense representation. So, and it's not their fault. We're trying to give them a tool through this. Mike, am I wrong?
No, that's absolutely correct, Mr. Chairman.
Trying to give you a tool to try to help you with guidance. So.
If I could respond in the sense that when you're opening 161,000 cases and you've got judges saying get this case ready for trial and get this person out of jail, it's very difficult for the lawyers to follow up on the affidavits. We take the applications. This is not an excuse for anyone being represented who shouldn't be. It's simply an explanation that with the numbers that we have, and without anyone in each individual office having the responsibility for following up on checking the affidavit, it's very difficult for the lawyers to do that. I think that the legislation probably is a good result of the work our Legislative Oversight Committee. When the Legislative Oversight Committee idea came up, everyone was worried about us having too many bosses. I've got 11 members of the Standards Council looking at what we do in establishing policy, and we have the members of the Legislative Oversight Committee. Quite frankly, our experience has been it's been the best thing that's happened to us because it's not only provided us with additional oversight, which is not a bad thing if it's done properly, it also provides us with access to the legislators And so it's not a bad thing. And this is something, the question that I've raised is, I hope the cost for these additional people it's not expected to come out of our budget because we're bare thin as it is now.
Let me make one comment. Some people don't have to leave to go to rules. We're going to try to meet during lunch. If everybody on the committee could, try to work on the recommendations where I know that most of y'all are going to try to leave town this afternoon. Yeah, I know you do. And that's why I will get with y'all on the floor and see if we can find somewhere to meet during lunch to try to work with the budget analysts to try to come up with some recommendations for everybody to get out of town in a hurry. One other thing I want to mention too, or ask Mike, on the working with y'all on interest, and I know Representative Knox has got a question. As soon as I ask this, then we'll get his. Looks like the whole committee's going to leave us with that. Everybody's on rules. I know where our friends are. Anyway, by using some IOTA funds, whatever it is, interest on a lot of these trust accounts, and with some jail fees, sheriff's office, aren't you possibly going to have some possible lapse money in this 06 budget? Possibly.
Possibly.
But in so doing, if you give up some of this money, you're going to need some additional money back in 07, if I understand it right.
Absolutely, Mr. Chairman. We are absorbing by using those funds and shifting them around from IOTA and the clerks and sheriffs. We'll be able to live within the budget as the funds are collected. My concern, and I think Sarah's concern, is also that when we come back in the 07 budget and in future budget, that y'all will look at that reduced budget as our continuation budget, and it really wouldn't be fair to expect us to continue operating on the budget that we're using absorbed funds and things, because we need the $42 million to operate on. We're absorbing some costs, making some cuts now because of the exigency of the budget now, but we're hopeful that y'all will realize that that's not our continuation budget, and when we come back for the 07 and 08 budgets, that you'll recognize that we made those cuts, not that that's what we have to live on every budget year. So that's my response to that.
We've gone back and forth on this, and I'm not sure I'm clear on it, and I'm just because I'm interested in the program in general. But is it a case that y'all really want to be responsible and involved in collecting that fee, or would you just assume somebody else did it and just make sure you got it?
We want to be a part of the process of collecting the fee. However, I'm not sure that we're the best agency or the best parties to this whole process to do the collection. We're the first responder, if you will, to these individuals. Right now, simply logistics of keeping track of $50 application fees is amazing, because we can't take cash. I mean, that would not be a physically responsible. We require the individuals to give us a money order, and then the money orders are batched and given to the clerks and sheriff's fund collectors. We're not opposed to someone else collecting that fee. We're not opposed to it at all.
A lot of those people don't even have it. I mean, if they're in jail, which is often the case, they don't have $50. They got picked up on the street with, crack pipe and something else in their pocket. And they don't have any cash. They just spend it all. And so, it seems to me like that's, I don't know how much of a distraction it is, but it seems like it'd be a fairly big distraction from the goal
Of representing.
Yeah.
If the legislature allows or gives the judges some direction that it should be tacked on as part of the probation cost, I think that you'll see a very large increase in it being collected, and it's probably being collected at the right point, because someone gets out of jail, put on probation, they get their job, then they can take out of their first paycheck that $50 fee to pay for the public defender services. Did I answer your question, Representative Knott?
Yeah, I think it's going to be. I think it's hard to do that. Some of those people are not going to be eligible for one thing, and they still owe you the application fee, and how are you going to get it from them?
Right.
Anything else, anybody?
Nothing.
Are y'all leaving?
We'll.
I'm going to stay. I need to see Sarah just a bit.
Okay, with your permission, I'll go back to the office and go back to work.
Fine, just take care of yourself. Mike's
Thank
had
you.
a lot of health problems in the last year. Scared a lot of folks.
If I could just say, invest in medical technology. Pacemakers and defibrillators are wonderful instruments that keep you going. Thank you.
Especially in Chicago.
Absolutely.
Thank y'all. David? I'm sorry our committee's left. I apologize.
Okay, yeah, okay. Thank you. Okay. Good morning, Mr. Chair. Thank you for having us here. I'm Deborah Nesbitt with the Administrative Office of the Courts. My director, David Ratley, is here. Our budget officer, Kevin Tolmich, and Vince Harris, who is over our administration division. We come to you today with a supplemental request. There are two items on here, the first one being for a personal security summit for the judges, and that request is being made through ICJE, which is Continuing Judicial Education. Given, oh, I'm sorry, on page 9 of 60. That's okay. The $10,000 is to have a personal security summit for the judges. In light of what happened last March, they felt it was important to try to train the judges and give them some tips on their personal security, and that's just one of an ongoing effort that we have. The second item is $121,206. That item is to provide state match for 4D money that comes from the federal government to fund the work of the Child Support Guidelines Commission. Our office staffs that commission, and that is an ongoing permanent commission that will continue to operate and review the guidelines, do economic studies and various studies about how that law has been implemented across the state. Some examples of, we have a staff attorney that's assisting that commission that pays for the meetings, that paid for a economic study to look at the worksheets and the tables. And so that will be an ongoing project. And so having that state match allows us to pull down 66% match. And so this would be our 33% match for the operation of the Guidelines Commission. And that's all of our supplemental requests. Do you have any questions?
I know we've had some ongoing conversations on some matters. I do know when we get to, for the committee's sake, when we get to the 07, we're going to spend a good bit of time with AFC to try to help them on. I will tell you what I have asked them to do, just for being honest. I've asked them to look at any cuts, and we're going to ask the rest of the judicial the same thing. Any cuts that they could absorb or could be threatened with, basically, to put them in a priority order from them to a priority for us. Also, in so doing, is to look at, we're going to ask all judicial to look at any overlapping programs, whether that is where AOC may be paying payroll for other agencies, this type of thing. And this is not threatening AOC or any of the agencies, but it's just to look at it from a business management type situation to see if there are overlaps that maybe someone can do better than somebody else at less cost, or while we're competing with each other within the judicial branch. And so, and we've talked about it, and we're going to take that and see what we can do to help AOC, the Judicial Council, and all of judicial. My personal feelings, and I'm having talked to the governor also about this, is to try to make sure that we get the most of the court services for the dollars spent in the judicial branch in the state. If that means more DAs and judges and public defenders and more training for them, more technology, whatever, that we can make the court system more efficient. To move cases and make sure that everybody's properly represented and trained in the process. Any questions? said a while ago, we're gonna try to